Edwards. Case number 25 CR 42649. Present before the court is Ms. Edwards, right?
Mm-hmm.
You're Ms. Edwards, right?
Yeah.
Represented by Mr. Engel. We have Mr. View from the prosecutor's office, Officer Martinez from probation, Ms. Kennard from the victim's advocate's office. We are here today for sentencing. Is Edwards, that indicates your requirements under the duty to notify and to enroll as a violent offender. Did you read that over with Officer Martinez? Did you read that over with Officer Martinez?
Yes, sir.
Is that your signature at the bottom?
Yes, sir.
Do you feel like you understand the contents of that document, or do you want me to read it to you?
I understand it.
Okay. All right, Mr. View, on behalf of the state.
Your Honor, before the state's presentation, Ms. Kennard does have a victim impact statement for the court on behalf of the two victims and their family.
On behalf of Robert, he said that Miss Edwards, he will not forget you. That slap, when you slapped him, hurt a lot, and that you also hurt his sister. As far as from the mom, Rebecca, she hopes, she doesn't know if Miss Edwards has children or not, but she wants that the defendant to know that this crime has greatly affected the kids, especially Robin. Poor Rebecca can't even go to the bathroom by herself because Robin doesn't want to be left alone. She even just walking to the information booth to try to get a hold of me broke down in tears. She has no sense of peace. The kids have no sense of peace. They are currently in counseling and will be in counseling for a while. And I think the family just wants the defendant to know that there is a great long-lasting effect on the kids due to the defendant's actions, and the family would like to see her sentenced to more than 10 years in prison.
Buckle up, guys. Today we are going to witness a courtroom hearing that quickly turns into a battle over credibility. What begins as a routine probation violation, hearing immediately becomes tense when the judge questions the defendant about his whereabouts, but he firmly denies being anywhere except home, with official records suggesting the exact opposite. The courtroom is instantly divided between two conflicting versions of the truth. The stage is now set for testimony that could completely change the outcome.
Thank you. Mr. View?
Your Honor, in terms of the state's recommendation for the case, I think there are a number of aggravating factors for the court to consider in terms of the seriousness and recidivism factors for the case. I think, first and foremost, that Miss Edwards was on supervision for multiple felonies at the time of this offense. We have major felony crimes of violence, the victims of which are innocent children, as Ms. Kennard indicated. I think the impact on these children of the defendant's crimes are significant, and the court should take those into consideration in determining the seriousness of the case and the appropriate sentence. I think it is telling that Miss Edwards was in no way really cooperative with the pre-sentence investigation in terms of what her personal situation was, denying any real substance abuse issues in the case, but at the same time testing positive for fentanyl and cocaine, amphetamines at the time. Clearly, at the time she was arrested on this offense, she was in possession of drug paraphernalia and likely was under the influence from the state's perspective at the time that she committed these offenses. I think that those factors the court can look at as aggravating factors in coming to an appropriate sentence. Thank you, Your Honor.
Mr. Martinez, anything from probation?
The only statement in regards to probation's standpoint on this case would be that due to the conduct that took place and the harm that was done to the victims, both children, the recommendation is that the defendant be sentenced to prison.
Mr. Engel?
Thank you, Your Honor. I'd first note our position is we do believe that the robbery offense should merge with the kidnapping offense. As I understand, the two kidnapping offenses would have different victims, and under 12th District and Supreme Court laws, that would probably be enough so that they would not merge, but the robbery appears to be the same course of conduct. As to this case...
Let's talk about merger first. Based upon the facts that are set forth in the PSI, I did read those facts. Also, Dr. Dichting's report did contain some facts as well. Having considered those, based on the facts of this case, I do think that the robbery charges merge into the kidnapping charges. So the court is going to go ahead and make that finding of merger. So we're going to be sentencing on the kidnapping charges only. There, we have 2 counts, different victims. I don't think that's even in dispute that those do not merge.
The hearing shifts as a police officer takes a stand and lays out the prosecution's case piece by piece. He explains how a Dodge Charger sped away at an extremely high speed, forcing officers into pursuit before the vehicle disappeared. Technology later helped narrow down its location, where the defendant was found carrying the car's key fobs. As the officer describes the defendant's change in behavior and suspicious explanations, the prosecution begins building a narrative that suggests this was far more than an unfortunate misunderstanding.
Kidnapped.
To sentence, oh, I'm sorry, if I may.
Go ahead.
Yeah, as to sentencing, Your Honor, I would refer the court to the NGRI evaluation that was done in this case. I believe it is part of the record. If not, we'd ask it be made part of the record here. And the reason I do that is because one of the things that Mr. View mentioned was a suggestion about a lack of acceptance of responsibility, a lack of remorse. And I think you see part of that is a reflection, or how the defendant may present is a reflection of the mental health issues that she had, which I suggest is a significant mitigating factor here. As the court is aware, she has a significant history of mental health issues, including hallucinations that prevent her from.
Ms. Edwards, stop looking back there. You look at me.
But I think what just happened, Your Honor, is a good illustration. I'm looking at page 2 of the NGI report, and even at that point, the NGI evaluator noticed that the defendant would sometimes appear distracted or laugh inappropriately. She was laughing inappropriately, for example, when I was going over some of the forms with her, and it's not, I think, any disrespect to the court or lack of understanding. That is a manifestation of some of the mental health issues that she has. And so I'd ask the court to take that into account, as well as her responsibility. I'm in no way minimizing the events here. They're obviously very serious events, and I'm sorry that for the trauma that the victims have held. So we'll just leave it at that.
Ms. Edwards, is there anything that you want to tell me?
No, sir.
So
The defense now takes its turn to challenge the officer's conclusions. Through careful questioning, attention is drawn to one crucial weakness. The officer never actually saw who was driving the speeding vehicle. Questions about surveillance footage, tracking technology, and the mechanics of the car's key fob are all raised to create uncertainty. While the prosecution relies heavily on circumstantial evidence, the defense works to remind the court that assumptions alone may not be enough to establish responsibility.
I agree with Mr. View that the aggravating circumstances in this case are significant. The harm to these victims is significant. I agree with Mr. Engel a little bit that you have some mental health issues, but it seems pretty clear from Dr. Nichting's report that she thinks that you are exaggerating your mental health symptoms. It appears also from the PSI that you sort of pull the mental illness card out and play it. And I do think that you have some mental health issues, but I do not think that they rise to anywhere near the level that you portray them to be. And I think that you are a danger to my community, Ms. Edwards. I'm going to sentence you to 6 years in prison on each of these charges. I'm going to order that they be served concurrently, so it is going to be a total of a 6 to 9 year prison term. The Reagan-Tokes or indefinite sentence applies, which means that you're presumed to be released at the minimum term, but they might keep you up to the 9 years if you don't behave yourself while you're there. Based upon this sentence, I find that you are indigent for the purposes of fines and costs. There will be no financial sanctions. This includes the mandatory period of post-release control. That means the adult parole authority is going to supervise you upon your release. That is going to be anywhere from 18 months to 3 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year. or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. We need to credit for the 153 days that you have already done. Is there anything else we need to do? Anything that I forgot?
You did order that she register with the victim.
Oh, yes, and she is required to register as a violent offender.
Nothing
else?
additional from the state judge. Thank you.
Nothing else, Your Honor.
All right, Ms. Edwards, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. Good luck to you, Ms. Edwards.
The defendant finally gets the opportunity to tell his own version of events. He explains that he had just purchased his dream car, became overwhelmed with excitement, left it running for only a short time, and claimed someone stole it before he returned. He also addresses questions surrounding his residence and probation conditions, admitting certain mistakes while insisting he never fled from police. His testimony is an attempt to replace suspicion with a believable personal story. Original Clip 5. The prosecution immediately begins testing every detail of that explanation. They question how someone who spent so much money on a valuable vehicle could leave it running unattended, especially after admitting concerns about theft. As the questioning grows sharper, every answer is measured against the earlier testimony. Both sides then summarize their arguments, leaving the judge with one central question. Does the defendant's story genuinely make sense, or does the evidence point somewhere else? Original Clip 6. At this stage, the courtroom reaches its turning point. The judge openly states that she is not convinced by the defendant's explanation and carefully explains why several parts of the story simply do not add up. After reviewing the testimony, she finds multiple probation violations to be true. The attorneys and probation officer then discuss the appropriate consequence, with the recommendation becoming increasingly clear as concerns over accountability take center stage. Original Clip 7. The hearing concludes with the judge delivering her final decision. After considering all the testimony and applying a lower legal standard required in a probation hearing, she determines that the defendant violated the conditions of his probation and committed the new offense. His probation is officially revoked, and he is sentenced to 3 years in prison. With the case now decided, the courtroom proceedings come to a close. If you enjoyed this courtroom breakdown, don't forget to like the video, subscribe to the channel, and we'll see you in the next video.